When federal courts unsealed thousands of pages connected to Jeffrey Epstein, the public expected a revelation. What they received instead was a record of testimony, a record of associations, a record of institutional decisions made behind closed doors. Among the individuals referenced in portions of those records was former U.S. President Donald J. Trump. Tonight, we examine what the documents state, what they do not establish, and what the broader case reveals about power, proximity, and accountability. Being named in legal filings does not constitute criminal wrongdoing unless determined by a court of law. This episode focuses on documentation, not speculation. Welcome to Arcane Echo True Crime. Here, we examine sworn testimony, official findings, and primary records, separating allegation from adjudication and association from criminal liability. To understand the unsealed records, we must first understand the structure that allowed Jeffrey Epstein to operate for years within elite circles. Epstein did not build his public identity through financial innovation or corporate leadership. He built it through proximity. Throughout the 1980s and 1990s, Epstein cultivated relationships across finance, academia, politics, entertainment, and royalty. Former associates described him as deliberate, someone who understood that access to powerful environments could create its own legitimacy. Access was currency. He positioned himself within elite social ecosystems in New York and Palm Beach. He acquired properties that later became central to investigations, a Manhattan townhouse and a Palm Beach estate. These residences were more than private homes. They were venues. According to later federal criminal proceedings, Epstein operated a sex trafficking enterprise involving underage girls. The allegations described a pattern of recruitment, abuse, and coercion that spanned years. In 2008, Epstein entered into a controversial non-prosecution agreement negotiated by then U.S. Attorney Alexander Acosta. The agreement limited federal prosecution in exchange for a state-level plea. Epstein served 13 months in custody under work release conditions. The deal drew intense criticism. Legal scholars questioned the scope of immunity provisions, which extended to potential co-conspirators. Victims later argued they were not properly informed before the agreement was finalized. Years later, federal courts ruled that victims' rights were violated under the Crime Victims' Rights Act due to failures in notification during plea negotiations. For many survivors, the justice system had moved forward without them. The Epstein case became not only a story about individual misconduct, but about institutional discretion. How does prosecutorial power function when the defendant has extraordinary resources? That question would linger long after Epstein's death. During the 1990s and early 2000s, Epstein moved within social circles that included prominent business leaders, entertainers, academics, and political figures. Among them was Donald Trump, then a real estate developer and public figure. Archival photographs and media coverage confirm that Trump and Epstein attended some of the same social events during that period. In a 2002 interview with New York Magazine, Trump described Epstein as a terrific guy. At that time, Epstein had not yet faced public criminal charges related to sex trafficking. Years later, after Epstein's criminal conduct became widely known, Trump stated publicly that he had not spoken to Epstein in years and denied involvement in his crimes. No court has found Trump criminally liable in connection with Epstein's trafficking operation. The existence of social association, documented through photographs and media interviews, became part of the public record, particularly following Epstein's 2019 arrest. The distinction between association and culpability would become central to public debate. In July 2019, Epstein was arrested again, this time facing federal sex trafficking charges in New York. The case did not proceed to trial. Epstein died in custody in August 2019. The U.S. Department of Justice and the medical examiner concluded his death was a suicide. Internal investigations later documented significant procedural lapses at the correctional facility, including failures in required monitoring protocols. Those failures fueled public concern about oversight and institutional competence, though no official findings established homicide. The focus shifted once again, not only to Epstein, but to the system surrounding him. The recently unsealed records stem primarily from civil litigation involving Ghislaine Maxwell and defamation proceedings connected to Virginia Giuffre. These files include deposition transcripts, sworn testimony, emails, and related filings. It is critical to understand what such documents represent. Depositions record statements made under oath. They do not automatically verify every claim within them. They are part of the evidentiary process, not judicial conclusions. In one deposition excerpt, Johanna Schoberg referenced conversations in which Epstein allegedly mentioned various public figures. Among those mentioned was Donald Trump. The testimony described reported remarks. It did not allege criminal conduct by Trump in that context. Virginia Giuffre also testified regarding her experiences within Epstein's network. In portions of her statements, she referenced comments Epstein allegedly made about powerful individuals. Those statements represent sworn testimony. They do not constitute judicial findings of criminal liability against those named. Trump has denied involvement in Epstein's trafficking operation. Flight logs entered into court records show that numerous high-profile individuals traveled on Epstein's aircraft at various times. Trump's name appears in certain manifests. Epstein's pilot, Larry Visosky, testified under oath that he did not observe Trump in the presence of underage girls. Flight manifests document travel. They do not, by themselves, establish criminal activity. The unsealed documents reveal who was mentioned. They reveal who testified. They reveal how networks intersected. They do not, on their own, establish criminal liability beyond what courts have determined. The Epstein case exposed more than individual misconduct. It illuminated how elite networks operate. In high-level social environments, business, politics, academia, proximity is common. Galas, fundraisers, conferences, private gatherings. The overlap of influence does not automatically imply shared wrongdoing. Yet when criminal conduct is later revealed, those associations are re-examined through a different lens. Sociologists often describe elite networks as closed circuits of trust, environments where reputation can substitute for scrutiny. In such systems, credibility can be inherited through association. The Epstein case forced institutions to confront uncomfortable questions. Were warning signs dismissed? Were reputational assumptions given too much weight? Did wealth and status influence prosecutorial outcomes? These questions extend beyond any single political figure. Names across multiple industries appear in various contexts within the documents. The larger issue is structural. Do institutions respond differently when power is involved? Reaction to the unsealed records reflected broader political divisions. Some argued that any documented association demanded moral examination. Others emphasized due process and the importance of judicial findings over implication. Media coverage ranged from analytical reporting to highly sensational framing. In polarized environments, proximity can quickly become narrative, but documentary analysis requires restraint. Primary documents must be read carefully. Context must precede conclusion. The Epstein case illustrates how quickly public discourse can outrun legal process. Transparency does not always provide closure. Sometimes it reveals complexity instead. The Epstein case remains one of the most consequential institutional scandals of the modern era, not because of any single name, but because of what it revealed about access, influence, and oversight. Federal courts confirmed that victims' rights were violated during the 2008 plea negotiations. Monitoring failures were documented in the 2019 detention. Public confidence in institutional accountability was shaken. The unsealed records add transparency. They do not resolve every question. They show who was mentioned, who was deposed, who traveled, who testified. But documentation is not adjudication. Testimony is not verdict. Association is not conviction. In cases involving power, clarity rarely arrives all at once. It is assembled slowly through filings, transcripts, and rulings. The responsibility of documentary inquiry is not to inflame. It is to examine. In moments where outrage is loud, evidence must remain steady. The record is public. The conclusions must remain grounded in law. This has been Arcane Echo True Crime. Thank you for watching and subscribe for more deep dive into real law enforcement discovery.